Today I'd like to talk to you about Standards Essential Patents, or SEP. What are they, why do they matter, and why are they valuable? Let's discuss it. So all of us use technology on an almost daily basis these days. Things like your mobile telephone, your laptop computer, and other digital devices that you use are usually subject to what are called technology standards. Technology standards are set and developed by what are called standard-setting organizations. Standard-setting organizations are usually comprised of various committees where each committee is dedicated to drafting and developing a certain aspect of the particular technology standard. One example that you may be familiar with is the 802.11 standard for Wi-Fi. The 802.11 standard has components to it, one of which is the wireless interface, others which may be hardware interconnectivity portions, and so on. Other standards that you might be familiar with are mobile device technology standards, such as 2G, 3G, 4G, and 5G. These standards determine how mobile devices communicate with the network that they're operating on and how the networks communicate with components within the infrastructure. Each piece of hardware may have a standard associated with it in terms of how that piece of hardware communicates with another like piece of hardware or other pieces of hardware within the infrastructure of the network. I've had the opportunity and privilege to work on many patents related to the 2G and 3G standards for cellular communications. What is a standard essential patent? A standards essential patent is defined as a patent that must be infringed if an entity is in compliance with the standard. In other words, it's essential or technically essential because by implementing the standard, you must use the technology described and claimed in the standards essential patent. Therefore, simply admitting that you're in compliance with the standard would by definition mean that you're using the technology described in the standards essential patents related to that standard. So why are these patents valuable? Well, it's related to the situation I just described. Usually for determination of infringement, a very detailed analysis has to be done comparing the claims of the patent to the accused infringing product. Every limitation of the claim has to be found in the accused infringing device. With standards essential patents, that burden is made somewhat easier by the fact that the infringer outwardly acknowledges and admits that they're in compliance with the standard. The position of a standards essential patent holder is that if a party admits to and acknowledges compliance with the standard, therefore they must be using the technology described and claimed in their standards essential patents. So the case for infringement is a very strong one, and because a technology standard must be complied with, patents that read on the standard become very valuable in that industry. Therefore, standards essential patents become very valuable in a certain industry because anyone that's developing products and complying with the standards in that industry by definition must be infringing the standard essential patents associated with that industry. Members of a given industry will usually have members on a standard setting organization and sitting in on one or more committees. Usually these members are engineers that are actively working to develop the technology associated with the standard. By being involved in the committee, they have an opportunity to not only help develop and guide the direction in which the standard proceeds, but to get information on the direction that the standard is going in so that their respective company can take action to remain in compliance with that standard and to plan for future compliance with the technology requirements of the particular standards document. Members of the standard setting organization normally have a duty to disclose any patents that they may have that are related to the standard so that other members of the committees can be aware that this intellectual property exists. The rule for licensing Standard Essential Patents is another acronym. I guess SEP people like acronyms, but the acronym for licensing in the SEP world is FRAND, which stands for Fair, Reasonable, and Non-Discriminatory. In other words, one company that has standard essential patents can't block their competitor from licensing their patents, and they can't charge outrageous licensing fees in order to block them from using the technology. They have to do it in this FRAND manner, fair, reasonable, and non-discriminatory. Now, over the years, there's been some disagreement about what FRAND actually means, and there are many court cases that go into discussion of what constitutes fair, reasonable, and non-discriminatory. But the details of those discussions won't be addressed here. Maybe I'll address those in a separate video. But for now, I just want you to be aware that standard essential patents are licensed under these philosophical conditions of FRAND. So technology companies in general in a certain industry will look to standards of their industry, send engineers to have committee involvement, to be actively involved in the development of those standards, and make attempts to develop patent portfolios that read upon the standards such that they have these valuable SEP patents in their portfolio. Can individual inventors also develop SEP patents? Yes, absolutely so. The SEP patent world is not limited to the large companies, although larger companies that have large research and development organizations and product development organizations are most likely going to have a large number of SEP patents, more so than an individual might have. However, individual inventors certainly can be aware of standards, look at standards in development, understand them, and develop products of their own and patents of their own that read on the standard. One thing to be aware of is that as standards are developed, they change over time. And what may be a draft standard at one point in time may not wind up being the ultimate standard after several years of iterations of the document with the various engineers involved in the SSO Standards Committee process. Therefore, in order to develop patents around standards, it's critical to remain aware of the developments that are happening within the various committees of the standard setting organization and looking at the draft documents to understand the direction that the standards are going. Knowing that, it's possible to develop patented technology around those standards. However, this is a very difficult task because, as I mentioned, the standard changes over time. Everyone involved in the committee, who may be engineers from competing companies with competing interests, are putting their input into the committee, and the committee as a whole is deciding what the best course of action is for that particular standard. In some cases, one technology company may drive the standard by having research and development far advanced from other committee members and therefore be in a better position to help guide what those standards should ultimately be. However, in most cases, committee members will be on a somewhat equal footing, having equal weight into what ultimately goes into the final product of the standard document. Now, these standard documents, for your information, can be hundreds of pages. Sometimes the various standard components can be thousands of pages. The 802.11 standard is a standard that has quite a number of documents associated with it. 3G, 4G, 5G are also very large standards documents. So reading them is not an easy task. Understanding them is also not an easy task, unless you have some knowledge about the technology area that those standards are related to. So to conclude, standard essential patents are very valuable patents in an overall portfolio. A standard essential patents or SEP portfolio can be very valuable to a technology company in a given industry that must comply with a particular technology standard for that industry. Independent inventors can also develop patents around these technologies if they have a view into the standard development process and an understanding of the technology art area involved. Certainly they can develop SEP patents of their own that can be licensed to the larger technology entities complying with the standards. I hope you enjoyed this video. Please give it a like and subscribe. I'll see you in the next video, and stay inventive.